Good afternoon, class. My name is Sara Fadaikar, and I'm going to be talking about the Glynn Environmental Coalition Incorporated, the Center for a Sustainable Coast Incorporated, Jane Fraser versus Sea Island Acquisition. Here are the facts of the case. Plaintiff appellants Glynn Environmental Coalition, the Center for a Sustainable Coast, and individual plaintiff Jane Fraser challenged Sea Island Acquisition's filling of a 0.49-acre wetland near their hotel in Glynn County, Georgia. The area qualifies as a wetland under the Clean Water Act. Sea Island sought and received a permit under Nationwide Permit 39 from the U.S. Army Corps of Engineers in early 2013 to fill the parcel, representing it was for constructing a commercial building. However, after filling the wetland, Sea Island did not develop a building. Instead, it sodded the area, creating an unnatural lawn. Fraser, who regularly recreates in and enjoys the natural aesthetics of such wetlands, alleged the fill diminished her aesthetic and recreational interests, turning a previously pleasing natural resource into a less aesthetically pleasing space. Plaintiffs brought suit, seeking declaratory and injunctive relief, penalties, and attorney's fees, arguing Sea Island violated the Clean Water Act by failing to comply with permitting and water quality certification requirements. The district court dismissed the complaint for lack of Article 3 standing. Our issue statement is going to be, does Jane Fraser and by the extension the environmental organizations have Article 3 standing based on a loss of aesthetic and recreational interest arising from the filling of the wetland, given that she regularly perceives and enjoys the wetland's aesthetics even without physically intruding the land itself. The rule here is going to be pertaining Article 3 of the Constitution. To satisfy Article 3 standing, a plaintiff must allege injury in fact that is concrete, particularized, and actual or imminent. The injury must be traceable to the defendant's conduct, and it must be redressable by a favorable court decision. At the pleading stage, general factual allegations can suffice if they plausibly allege a concrete injury, specifically where the plaintiff uses the area and it's harmed. The 11th Circuit has recognized that a plaintiff need not physically enter the site to claim an aesthetic injury, nor must she have previously visited it to establish a standing. So the application here, the injury in fact, Fraser plausibly alleged that she derived aesthetic pleasure from viewing the wetland and that filling it diminished that enjoyment. Her business of regularly recreating in and appreciating the wetland satisfies concreteness and particularization. The transformation to an unnatural lawn constitutes a tangible lessening of her recreational and aesthetic interest. This is a real personal stake and not abstract harm. The 11th Circuit explicitly rejected Sea Island's arguments that Fraser needed to have physically visited the wetland or derived pleasure from it prior to the fill. The plaintiff did not need to have previously derived pleasure from the wetland to suffer an injury from loss of aesthetic pleasure after its filling. The court analogized that requiring physical entry would force absurd results. Traceability. The harm is traced directly to Sea Island's filling of the wetland, the act that changed its condition and diminished its aesthetic and recreational value. Redressability. A favorable court decision, such as an injunction restoring the wetland, would presumably remedy the aesthetic harm by restoring the natural condition that Fraser enjoyed. Because all these elements were satisfied at the motion to dismiss stage, the 11th Circuit held that plaintiffs have standing. The conclusion here was that the 11th Circuit vacated the district court's dismissal for a lack of standing and remanded the case. Further proceedings are considered, and the allegations concerning the diminished aesthetic and recreational use of a specified wetland were sufficient to establish Article 3 standing at the pleading stage. Thank you for listening, and